Hey, I'm Paul Rabley. I'm an estate planning attorney coming to you from on a Saturday. Wanted to clear up some things about what's needed to start a succession. Here's the situation. I've seen it a million times. Family waits a few weeks until, or sometimes months, before they get the death certificates. Then they schedule a time to come see me, the attorney. They come in, they've got an envelope with their death certificates, and we start the conversation. And then it usually goes, well, they usually say something like, Paul, before we get started, I know you're going to need this, so let me give this to you. And they pull a death certificate. They probably have 10 or 15 of them in there. They pull the death certificate out that has all the state seal and everything on there. And they're saying, let me give this to you before we get started because I know you're going to need it. And, at that moment, I kind of have to say something like, no, we're not going to need it. And so it always kind of starts the meeting off a little funny because there's just been this anticipation of getting the death certificate so we can start the estate settlement process. And I'm the attorney sitting here saying, nah, don't need them. So yes, we do in a succession, or some people call it probate, which is the process when somebody dies with something in their name. Those things are frozen. We've got to go through a court process to get them handled the right way and transferred to the appropriate heirs. There is a mechanism where we need to prove to the proper court that the person died, his marital status, where he lived, did he have children. But that's all done by what's called affidavits. So we don't file death certificates at the courthouse. So typically two people, the requirement is two people who were kind of familiar with or had knowledge of the facts, sign these affidavits stating so-and-so died on such and such date. He was married to so-and-so. He had a will. He had children. And that takes care of it. And we don't do anything with the death certificates at the courthouse. So the statement of it won't do any good to meet with the attorney until we get the death certificates is, quite frankly, inaccurate. Now, what do you need to get started? So let's talk about that, because the death certificates often take weeks, or in some cases months, to come in. We are dealing with the state of Louisiana, so that's another story. So what do you need to get started? Well, you need the original will if one exists. So it's kind of silly when a family comes in and the deceased person had a will, but the survivors don't bring the will with them. The actual wording, word for word wording of what it says in the will, is really important and dictates how all of the court pleadings get prepared. So we have to have that, first thing. And really, it's important to bring in the original will, not a photocopy, because, in our office, we get these court pleadings prepared very, very quickly. And so we need to file that original will at the courthouse with the initial set of court pleadings. So it really is important that you bring in the original will. That will ultimately be filed at the courthouse. Some people think when they signed their will years ago that it was filed at the courthouse, but it wasn't. So bring in that deceased person's original will so that not only can the attorney review it, but it's going to need to be filed at the courthouse. What else do you need besides the original will? You need two people who have knowledge of these facts that I mentioned earlier to sign these what's called affidavits of death, domicile, and heirship. It's typically two family members. Maybe it's that surviving spouse, if there is a surviving spouse. Maybe it's one or two of the children, and so those people who have knowledge of the facts can sign these affidavits. And again, that takes the place of having to file death certificates at the courthouse. So original will, two people who can sign the affidavits, and then if you're really on your game, you'll bring in a list of all of the assets that the person owned and the values on the date that that person died. That's not necessarily necessary day one of starting the succession, but there will be a list of assets and debts as of the date of death prepared and put in the right format, filed at the courthouse, but typically not, on that first day or two when a succession gets started. So now there is a need for death certificates, but that comes later. That comes in one of two sets of circumstances. One, if there is what's called an executor confirmed, or if no will and administrator appointed, Once that executor is confirmed or the administrator appointed, then that executor or administrator will need a death certificate to go to the bank and open up an estate account to perhaps move funds that are in the deceased's frozen accounts into the new estate account. The bank's going to need a death certificate to open that estate account, but that comes later. You can start the process of getting the executor confirmed. That usually takes a few weeks. And then once they are confirmed, you'll probably have the death certificates by then so the executor can open the estate account. Or you'll need death certificates once the final judgment of possession is rendered. That's that final court order that a judge signs ordering the various financial institutions to release or transfer funds or investments to the appropriate heirs. When that final judgment comes in from the courthouse and the attorneys, including myself, get you what's called certified copies of that judgment, you'll also need a death certificate with that certified copy of the judgment to take to the financial institution. The financial institution's going to need a death certificate before they'll release the funds to the appropriate heirs. So don't need a death certificate to get started. And since delays are one of the main complaints about probate, it makes sense to get started as soon as practical, really after someone dies. It sometimes makes sense to get started just, a few days after the person dies, particularly if family members are in town and they all want to meet with the attorney, and the attorney can make everybody feel good about what all the steps are. Things are going to be done right. There's a process. Then, the family starts, having trust with one another, open communication, rather than when there's delay and nobody knows what's going on. That sometimes causes some family stress. So delaying the start of the succession, or in some cases they call it probate, is really unnecessary. You're unnecessarily waiting weeks, or in some cases months, to start a process that's gonna take what many people perceive as a long time anyway. So you can get that thing started right away. Hope that helps. I'm Paul Rabelais. Have a great day.